Bouvier Law Dictionary. A law dictionary, adapted to the Constitution and laws of the United States of America and of the several states of the American Union. By John Bouvier, revised 6th edition, 1856. Select the first letter of the word you want to look up. There are no entries for X or Z. HTML version. A B C D E F G H I J K L M N O P Q R S T U V W X Y Z. Text version. A B C D E F G H I J K L M N O P Q R S T U V W X Y Z. Home Constitution Society. http://www.constitution.org/bouv/bouvier.htm10/10/20052 4:52 p.m. Bouvier's Law Dictionary, 1856 edition, Letter A. Bouvier's Law Dictionary, 1856 edition. A. The first letter of the English and most other alphabets, is frequently used as an abbreviation, Q, verses and also in the marks of schedules or papers, as Schedule A, B, C, and C. Among the Romans, this letter was used in criminal trials. The judges were furnished with small tables covered with wax, and each one inscribed on it the initial letter of his vote, A, when he voted to absolve the party on trial, C, when he was for condemnation, and NL, non licet when the matter did not appear clearly, and B desired a new argument. A mensa et thoro, from bed and board. A divorce, a mensa et thoro, is rather a separation of the parties by act of law, than a dissolution of the marriage. It may be granted for the causes of extreme cruelty or desertion of the wife by the husband. 2 Eccle. Rep. 208. This kind of divorce does not affect the legitimacy of children, nor authorize a second marriage. V. A vinculo matrimony, cruelty divorce. Apprendre, French, to take, to seize, in contracts, as profits apprendre. Ham. N. p. 184, or a right to take something out of the soil. 5 Ad an L. 764, 1n. And p. 172 it differs from a right of way, which is simply an easement or interest which confers no interest in the land. 5b. And c. 221. A quo, a Latin phrases which signifies from which, example, in the computation of time, the day a quo is not to be counted, but the day ad quem is always included. 13 Tool. N. 52, 2 Duve, N. 22. A court, a quo, the court from which an appeal has been taken, a judge, a quo is a judge of a court below. 6 Mart Lo R. 520, 1 Har. Cond. L. R. 501. C. Ad quem. A rendre, French, to render, to yield, contracts. Profits a rendre, under this term are comprehended rents and services. Ham N. p. 192. A vinculo matrimony, from the bond of marriage. A marriage may be dissolved a vinculo, in many states, as in Pennsylvania, on the ground of canonical disabilities before marriage, as that one of the parties was legally married to a person who was then living, impotence, q. verses, and the like, adultery, cruelty and malicious desertion for 2 years or more. In New York, a sentence of imprisonment for life is also a ground for a divorce a vinculo. When the marriage is dissolved a vinculo, the parties may marry again, but when the cause is adultery, the guilty party cannot marry his or her paramour. Ab initio, from the beginning. 2. When a man enters upon lands or into the house of another by authority of law, and afterwards abuses that authority, he becomes a trespasser ab initio. Back. A flat trespass, b. A coke, 146 2 BL Rep. 1218. http://www.constitution.org/bouv/bouvier_a.htm 1 of 237, the 10th of October 2005, 2 hours 18 minutes and 8 seconds p.m. Bouvier's Law Dictionary, 1856 edition, Letter A. Clate. 44. and if an officer neglect to remove goods attached within a reasonable time and continue in possession, his entry becomes a trespass ab initio. 2 BL Rep. 1218. See also as to other cases, 2 Straw. 717 1H. BL 1311 East, 395 2 Camp. 115 2 Johns. 191, 10 Johns. 253, Ibid. 369, 3. But in case of an authority in fact, to enter, an abuse of such authority will not, in general, subject the party to an action of trespass. Lane, 90, Bay. A flat trespass, B, 2t. It 166. See generally 1 Chit. Pi 146. 169. 180. ABINTESTAT. An heir, ab instat, is one on whom the law casts the inheritance or estate of a person who dies intestate. ABIRATO, civil law. A Latin phrase, which signifies by a man in anger. It is applied to bequests or gifts, which a man makes adverse to the interest of his heir, in consequence of anger or hatred against him. Thus a devise made under these circumstances is called a testament ab erato. And the suit which the heirs institute to annul this will is called an action ab erato. Merlin, Riepert. Mo a flat erato. Abandonment, contracts. In the French law, the act by which a debtor surrenders his property for the benefit of his creditors. Merle. Representative mo abandonment. Abandonment, contracts. In insurances, the act by which the insured relinquishes to the assurer all the property to the thing insured. 2. No particular form is required for an abandonment, nor need it be in writing, but it must be explicit and absolute, and must set forth the reasons upon which it is founded. 3. It must also be made in reasonable time after the loss. 4. It is not in every case of loss that the insured can abandon. In the following cases an abandonment may be made: when there is a total loss, when the voyage is lost or not worth pursuing, by reason of a peril insured against, or if the cargo be so damaged as to be of little or no value, or where the salvage is very high, and further expense be necessary, and the insurer will not engage to bear it, or if what is saved is of less value than the freight, or where the damage exceeds 1/2 of the value of the goods insured, or where the property is captured, or even detained by an indefinite embargo, and in cases of a like nature. 5. The abandonment, when legally made, transfers from the insured to the insurer the property in the thing insured, and obliges him to pay to the insured what he promised him by the contract of insurance. 3 Kent, Com 265, 2 Marsh. Inns. 559 Pard. Dr. Coyne. N. 836 et seq. Boulay Patey, Dr. Com Maritime, Tit. 11, Tom. 4, page. 215. Abandonment. In maritime contracts in the civil law, principals are generally held indefinitely responsible for the obligations which their agents have contracted relative to the concern of their http://www.constitution.org/bouv/bouvier_a.htm 2 of 237 the 10th of October 2005 2 hours 18 minutes and 8 seconds p.m. Bouvier's Law Dictionary, 1856 edition, Letter A Commission. But with regard to ship owners there is remarkable peculiarity. They are bound by the contract of the master only to the amount of their interest in the ship, and can be discharged from their responsibility by abandoning the ship and freight. Poth. Chartes Part. S. 2, Art. 3, 51, Ord. de Lamar, des Propriétaires, Art. 2, Code de Com 1. 2, T. 2, Art. 216. Abandonment, lights. The relinquishment of a right, the giving up of something to which we are entitled. 2. Legal rights, when once vested, must be divested according to law, but equitable rights may be abandoned. 2 Wash. R. 106. C1H. An M429, a mill site, once occupied, may be abandoned. 17 Mass. 297, an application for land, which is an inception of title, 5s. And R. 215, 2s. And R. 378, 1 Yates, 193, 289, 2 Yates, 81, 88, 318, an improvement, 1 Yates, 515, 2 Yates, 476, 5 Bin. 73, 3s. And R. 319, Jones Syllabus of Land Office Titles in Pennsylvania, Chap. XX, and a Trust Fund, 3 Yerg. 258 may be abandoned. 3. The abandonment must be made by the owner without being pressed by any duty, necessity or utility to himself, but simply because he wishes no longer to possess the thing, and further it must be made without any desire that any other person shall acquire the same, for if it were made for a consideration, it would be a sale or barter, and if without consideration, but with an intention that some other person should become the possessor, it would be a gift, and it would still be a gift though the owner might be indifferent as to whom the right should be transferred. For example, he threw money among a crowd with intent that some one should acquire the title to it. Abandonment for torts, a term used in the civil law. By the Roman law, when the master was sued for the tort of his slave, or the owner for a trespass committed by his animal, he might abandon them to the person injured, and thereby save himself from further responsibility. 2. Similar provisions have been adopted in Louisiana. It is enacted by the Civil Code that the master shall be answerable for all the damages occasioned by an offense or quasi-offense committed by his slave. He may, however, discharge himself from such responsibility by abandoning the slave to the person injured, in which case such person shall sell such slave at public auction in the usual form, to obtain payment of the damages and costs, and the balance, if any, shall be returned to the master of the slave, who shall be completely discharged, although the price of the slave should not be sufficient to pay the whole amount of the damages and costs, provided that the master shall make abandonment within 3 days after the judgment awarding such damages shall have been rendered, provided also that it shall not be proved that the crime or offense was committed by his order, for in such cases the master shall be answerable for all damages resulting therefrom, whatever be the amount, without being admitted to the benefit of abandonment. Art. 180, 181. 3. The owner of an animal is answerable for the damages he has caused, but if the animal had been lost, or had strayed more than a day, he may discharge himself from this responsibility, by abandoning him to the person who has sustained the injury, except where the master has turned loose a dangerouser. http://www.constitution.org/bouv/bouvier_a.htm 3 of 237, the 10th of October 2005, 2 hours 18 minutes and 8 seconds p.m. Bouvier's Law Dictionary, 1856 edition. Letter A. Noxious animal, for then he must pay for all the harm he has done, without being allowed to make the abandonment. I.B. Art. 2301. Abandonment, malicious. The act of a husband or wife, who leaves his or her consort willfully, and with an intention of causing perpetual separation. 2. Such abandonment, when it has continued the length of time required by the local statutes, is sufficient cause for a divorce. Vide 1 Hoff. R. 47, Divorce. Abatement, chancery practice, is a suspension of all proceedings in a suit, from the want of proper parties capable of proceeding therein. It differs from an abatement at law in this, that in the latter the action is in general entirely dead, and cannot be revived. 3 BL. Com 168. But in the former, the right to proceed is merely suspended, and may be revived by a bill of reviver. MITF. EQ Place by Jeremy, 57, Story, EQPI 354. Abatement, contracts, is a reduction made by the creditor, for the prompt payment of a debt due by the payer or debtor. Wesk. On Inns. 7. Abatement, Merck, Law. By this term is understood the deduction sometimes made at the custom house from the duties chargeable upon goods when they are damaged. See Act of Congress, March 2, 1799, s. 52, 1 story L. U. S. 617. Abatement, pleading, is the overthrow of an action in consequence of some error committed in bringing or conducting it when the plaintiff is not forever barred from bringing another action. 1 Chit. Place 434. Abatement is by plea. There can be no demurrer in abatement. Wiles Rep. 479, Salk. 220. 2. Pleas in abatement will be considered as relating, 1. To the jurisdiction of the court, 2. To the person of the plaintiff, 3. To that of the defendant, 4. To the writ, 5. To the qualities of such pleas, 6. To the form of such pleas, 7. To the affidavit of the truth of pleas in abatement. 3. 1. As to pleas relating to the jurisdiction of the court, see Article Jurisdiction, and Arch. Civ. Place 290, 1 Chit. Pi Index. Tit. Jurisdiction. There is only one case in which the jurisdiction of the court may be inquired of under the general issue, and that is where no court of the country has jurisdiction of the cause, for in that case no action can be maintained by the law of the land. 3 Mass. Rep. Ray v. Hayden, 1 Dougal, 450, 3 Johns. Rep. 113, 2 Penn. Law Journal 64, Meredith v. Peary. 4. 2. Relating to the person of the plaintiff. 1. The defendant may plead to the person of the plaintiff that there never was any such person in rerum natura. Bro. Brief, 25, 19 Johns. 308 Com. Dig. Abatement, E16. And if one of several plaintiffs be a fictitious person, it abates the writ. Com. Dig. Abatement, E16, 1 Chit. Place 435, Arch. Civ. Place 304. But a nominal plaintiff in ejectment may sustain an action. 5 Verm. 93, 19 John. 308. As to the rule in Pennsylvania, see 5 Watts, 423. http://www.constitution.org/bouv/bouvier_a.htm 4 of 237 the 10th of October 2005 2 hours 18 minutes and 8 seconds p.m. Bouvier's Law Dictionary, 1856 edition, letter A. 5. 2. The defendant may plead that the plaintiff is a feme covert. Colit. 132, b, or that she is his own wife. 1 Brown. Ent. 63, and C3t. R. 631, 6t. R. 265, Com. Dig. Abatement, E6, 1 Chit. Place 437, Arch. Civ. Place 302. Coverture occurring after suit brought as a plea in abatement which cannot be pleaded after a plea in bar, unless the matter arose after the plea in bar, but in that case the defendant must not suffer a continuance to intervene between the happening of this new matter, or its coming to his knowledge, and pleading it. 4 S&R. 238, back. ABR. Abatement, G. 4 Mass. 659, 4s. And R. 238, 1 Bailey, 369, 4 Vern. 545, 2 Wheat. 111, 14 Mass. 295, 1 Blackef. 288, 2 Bailey, 349. C10s. And R. 208, 7 Verm. 508, 1 Yates, 185, 2 Dahl. 184, 3 Bibb, 246. 6. 3. That the plaintiff, unless he sue with others as executor, is an infant and has declared by attorney. 1 Chit. Place 436, Arch. Civ. Pi 301, Arch. PRB. R. 142, 2 Sond. 212, A. N. 5, 1 went. 58, 62, 7 John. R. 373, 3 N. H. Rep. 345, 8 Pick. 552, and C7 Mass. 241, 4 Halst. 381 2 N. H. Rep. 487, 7, 4. A suit brought by a lunatic under guardianship, shall abate. Brait. 18, 8, 5. Death of plaintiff before the purchase of the original writ, may be pleaded in abatement. 1 Arch. Civ. Pi 304, 5, Com Dig. Abatement, E17. Death of plaintiff pending the writ might have been pleaded since the last continuance, Com Dig. Abatement, H32, 4 Hen. N Munef. 410, 3 Mass. 296, Cam. And Nor. 72, 4 Hawks. 433, 2 Root. 57, 9 Mass. 422, 4 H. N M. 410, Gilmer. 145, 2 Rand. 454, 2 Greenell. 127. But in some states, as in Pennsylvania, the death of the plaintiff does not abate the writ. In such case the executor or administrator is substituted. The rule of the common law is, that whenever the death of any party happens, pending the writ, and yet the plea is in the same condition, as if such party were living, then such death makes no alteration, and on this rule all the diversities turn. Gilb. Com. Pleas 242. 9, 6. Alienage, or that the plaintiff is an alien enemy. Back. ABR. H. T. 6 Bin. 241, 10 Johns. 183, 9 Mass. 363, ID 377, 11 Mass. 119, 12 Mass. 8, 331. NS. 533, 2 John. CHR. 508, 15 East, 260, Com Dig. Abatement, E4, ID Alien, C5, 1S. And R. 310, 1 CHPI 435, Arch. Civ. Pi 3, 301. 10, 7. Misnomer of plaintiff may also be pleaded in abatement. Arch. Civ. Pi 305, 1 Chitty's pleading, Index, Tit. Misnomer. Com Dig. Abatement, E19, E20, E21, E22, L Mass. 75, Back. ABR. H. T. 11, 8. If one of several joint tenants, sue in action ex contractu, co. Lit. 180, B. Back. ABR. Joint tenants, K. 1B. And P73, one of several joint contractors, Arch. Civ. Pi 48 to 51, 53, one of several partners, Gao on part. 150, one of several joint executors who have proved the will, or even if they have not proved the will, 1 Chit. Pi 12, 13, one of several joint administrators, Ibid. 13. The defendant may plead the nonjoinder in abatement. Arch. Civ. Place 304, C. Com Dig. Abatement, E9, E12, E13, E14. 12. 9. If persons join as plaintiffs in an action who should not, the defendant may plead the misjoinder in abatement. Arch. Civ. Pi 304, Com Dig. Abatement, E15. 13. 10. When the plaintiff is an alleged corporation, and it is intended to contest its existence, the defendant must plead in abatement. Right. 12, 3 Pick. 236, 1 Mass 485, 1 Pet. 450, 4 Pet. 501, 5 Pet. http://www.constitution.org/bouv/bouvier_a.htm 5 of 237 the 10th of October 2005 2 hours 18 minutes and 8 seconds p.m. Bouvier's Law Dictionary, 1856 edition, letter A. 231. To a suit brought in the name of the judges of the county court, after such court has been abolished, the defendant may plead in abatement that there are no such judges. Judges, and Century v. Phillips, 2 Bay,